In this subunit, we continue our discussion of consideration by focusing on the exchange requirement. All right, let's take a quick look and see how the requirement of exchange fits into consideration. Remember, we said a promise is not enforceable unless the promisee pays something for it, and we said the promisee has to give something of legal value in exchange for the promise. Now, we've already talked about legal value. Let's talk about what exactly it means for the promisee to give something of legal value in exchange for the promise. All right, here's a little example. Bob says to Mary, I promise to give you a car for your birthday next month. Mary says, thank you. We recognize this as the gift promise. It's a fact pattern we've seen before. Is Bob's promise legally binding? Well, did Mary give anything of legal value in exchange? Did she suffer a legal detriment? And the answer is no. Mary suffered no legal detriment. But let's change the facts just a little bit for fun. Let's say that in response to Bob's promise, Mary goes out and buys a parking pass at her university. She's going to get a car. She needs a parking pass. So she goes out and buys a parking pass at her university. Has she suffered a legal detriment? Yes. So does that mean that Bob's promise is supported by consideration? The answer is no. Even though Mary suffered a legal detriment, she did not give that in exchange for Bob's promise. Bob was not seeking for Mary to buy a parking pass in exchange for his promise. What was Bob seeking in exchange for his promise? Nothing. It was a gift promise. So sometimes when we talk about consideration, we'll talk about legal detriment, but the focus of the legal detriment should be that it was given in a bargained for exchange. In this subunit, we're going to talk about situations where there is no consideration, even though at first blush there appears to be consideration. All right. We're going to talk about the detrimental reliance situation. We're going to talk about the conditional gift promise. We'll talk about sham consideration. We'll talk about past consideration. And we'll talk about a recitation of consideration. We'll look at each of these situations in turn. We'll see that in most, if not all, the promisee suffers a legal detriment, but there is no consideration because the legal detriment was not given in exchange for the promise. First, let's talk about detrimental reliance. Here's a fact pattern, and this is the fact pattern that we just discussed. Bob says to Mary, I promise to give you a car next month for your birthday. Mary says, thank you. Mary buys a parking pass at her university. All right, did Mary suffer a legal detriment? Yes. Was it given in exchange for Bob's promise? No. So this is the situation where we have a legal detriment. We'll call it detrimental reliance. Why? Well, it's reliance. Mary suffered the legal detriment in reliance of Bob's promise, but she did not give the legal detriment in exchange for Bob's promise. Bob was not trying to induce Mary into buying a parking pass. Okay? In this situation, there is no consideration. Bob's promise is a gift promise, and therefore Bob's promise is not enforceable. In Unit 6, we'll talk about promissory estoppel. And under promissory estoppel, Bob's promise might be enforceable. But for now, Bob's promise is not supported by consideration, and therefore it is not enforceable. That is the issue of detrimental reliance. All right, we just talked about detrimental reliance. Let's talk about a closely related type of fact pattern, the conditional gift. So here's the promise by Mary. I have the book at home. Let's say Bob wants a book that Mary has. Mary says, I have the book at home. If you come to my house, I will give it to you. Okay? Bob goes to Mary's house to pick up the book. Mary refuses to give the book to Bob. What's our question? Is Mary legally obligated to abide by her promise? Must Mary give the book to Bob. Well, did Bob suffer legal detriment? Yes, he suffered a legal detriment. He went to Mary's house. Was he under legal obligation to go to Mary's house? No. So he did something which he had no legal obligation to do. This fact pattern looks very much like the unilateral contract fact pattern, doesn't it? It looks like Mary was making a promise and seeking return performance, but it is not. Why? Because Bob going to Mary's house was not exchanged for Mary's promise. Mary was not seeking to have Bob come to her house. It was just a condition of the gift. This is a conditional gift. It looks very much at first blush like the promise seeking performance, but it is not. Mary is just saying, I will give you the book. It's at my house. Come pick it up. Okay? Once again, going to Mary's house was just a condition to receiving the gift. Mary was not inducing Bob. Mary was not using her promise to induce Bob to come to her house. Let's look at a famous fact pattern and see if you can see how it fits into our discussion so far. All right. A man is walking on the street on a cold day and he sees a homeless person without a coat. And out of the goodness of his heart, man says, if you come to my office this afternoon, I will give you a coat. All right. So if the homeless person goes to the office, is the man obligated, legally obligated, to give the homeless person a coat? And the answer is no. Why? Because the man's promise was not supported by consideration. Did the homeless person suffer legal detriment by going to the man's office? Yes. But you'll notice that this was just a conditional gift. The man was not trying to induce the homeless person to go to his office. Going to the office was just a condition to receive the gift. So the man's promise is not legally binding. All right, let's move on to the next topic of exchange, sham consideration. Let's say that one party makes a promise and the other party in return pays $1 for that promise. Right? This is the virtual peppercorn, is it not? We talked about this issue. We talked about this issue when we talked about the adequacy of consideration. And we said, you know what, the courts will not look at the adequacy of consideration, but they will ask, was this a real exchange? Was the party who made the promise actually seeking $1 in return? Or was it just a disguised gift promise where one party made a promise and the other party really made no promise? The other party suffered no legal detriment except giving up the $1. Wink, wink. All right, so here's a fact pattern that happened to my family when I was a child. A TV ratings company came to our family and said, will you keep track of your TV watching habits so we can create TV ratings? And we said, sure. So we made a promise. Our promise is we will keep track of our TV watching habits. And so they gave us a little book where we were supposed to write down what we watched, how long we watched. Naturally, it was far more work than we anticipated, and we didn't do it. Right? Were we bound by our promise to do this? Well, they did, in fact, give us $1. They actually gave us $1 to do this. Were we bound? No, we were not bound. Why? Because it was just sham consideration. We made a promise, and effectively that promise was a gift promise, and the $1 was sham consideration. They were trying to make a gift promise look like it was an exchange, and it was not. In any case, they weren't going to sue us. But I think what they were trying to do is they were trying to make it look like it was a legally binding promise so that we would take it seriously and do it. It didn't work. It was just too much work, especially for $1. Let's talk about another situation where at first blush there appears to be an exchange, but on closer examination there is no exchange. This is called the past consideration situation. Now, past consideration really isn't consideration. So let's look at the fact pattern. We have a worker on a demolition site using explosives. After setting the fuse, the boss carelessly walks onto the demolition site and is in danger. The worker saves the boss from the explosion, but in the process, she is severely injured. The boss, in gratitude, says, "I will pay you $500,000 in consideration of saving my life." So, is this promise enforceable? Well, here's the situation. We have a promise, and we have legal detriment on the part of the promisee. Did the worker suffer legal detriment? Yes, the worker was under no legal obligation to save the boss. But here's the problem. It wasn't exchanged for the promise. Why? The worker suffered the legal detriment before the boss made a promise. So in this situation, boss's promise is not supported by consideration. Therefore, under consideration analysis, it is not legally enforceable. And you might be unhappy about that result, but we'll talk about that more when we talk about promissory estoppel. Or, as the slide says, maybe you can sue in quasi-contract. I conferred a benefit on you. Can you sue in quasi-contract? Probably not. Why? Because it was gratuitous. When you rescue someone, it is gratuitous. All right, moving on to the next topic. This one is really easy. It looks hard because it's a word you've never seen. Recitation of consideration. It's a term you're unfamiliar with. What is a recitation of consideration? Well, imagine we have a written contract. And in the written contract, we have this: for good and valuable consideration. This is not consideration. You can't just write in a contract that there has been consideration when there has not. Now, maybe in this transaction, there was actual consideration. There was something given in exchange for the promise. But just writing down for good and valuable consideration is not consideration. And this will happen sometimes. So we could go back to the TV ratings company example, coming to my house and my family saying, yes, we will keep track of our TV watching habits. In that case, they gave us $1. But maybe they'll ask us to sign a contract, and in the contract it'll say for good and valuable consideration. We made this promise for good and valuable consideration. Well, there was no good and valuable consideration. Writing it in a contract is not a substitute for actual consideration.